was Justice Sandra Day O'Connor who, when she voted for affirmative action, who stated that, in 25 years' time, this action we're taking today will no longer be necessary. Well, it's been 19 years, and affirmative action got knocked down in two different decisions, one involving college admissions at the University of North Carolina, which was a 6-3 decision, and one at Harvard, which was a 6-2 decision because Justice Ketanji Brown Jackson was working at Harvard and therefore recused herself from the case. The problem is that I don't think people really understand what affirmative action ever was to begin with, nor do they understand how it got played out. And when you take a look at how the colleges view this and this idea of race-conscious admissions, were they already working on an end around to the idea that they were admitting this student because they were this color and keeping this student out because they were that color? And why can't a private university do that to begin with? Guys, welcome to the show. Good to be with you. Brought to you by Americans for Prosperity. AmericansForProsperity.org. Economic liberty, free speech. That's where it's at. Let's bring in a guy who knows more than us. William Jacobson, Cornell law professor, the mind behind legalinsurrection.com. Let's start with the basics, sir. Let's start with the concepts of first off, what is affirmative action? How does the whole thing come to be? And what is it that the court decided in these two decisions?
Well, if you look historically back at affirmative action, going back to the 1970s, it was viewed as mostly remedial, that there had been multiple decades prior to that when blacks were excluded from many schools, when there was overt racism and overt discrimination. And so affirmative action was viewed as a way of making up for people who had been excluded. That was fairly narrow, and that is still consistent with the law, that if you can show that a specific government department specifically excluded people on the basis of race, you can engage in affirmative action to cure that. But it's very specific. It has to be that unit, and it has to be very provable. But affirmative action over time turned into something a lot more, and it received a huge helping hand from the Supreme Court in 2003 in the Grutter case, as relates to higher education, where they held that having a diverse student body in and of itself was a potentially compelling state interest that would allow for some narrow and clearly defined and time limited favoritism on the basis of race. So affirmative action has changed over time from trying to cure close in time discrimination that had taken place really up until the 1960s to now it's simply an agenda item to promote one race over another.
As a matter of law, and I'll give you a second there just to clear your throat and get yourself a drink. As a matter just of sheer law, as a matter of where the Constitution sits, should the federal government, should we have a say in whether or not a university can admit anybody for any reason or not admit anybody for any reason?
Well, there's a lot of factors there, and my throat is going to continue to be a little bit clogged. Sorry about that.
No problem.
There's nothing I can do. These schools all are either public institutions or they receive federal money. And when you take that federal money, you have to comply with a variety of federal regulations. And when you are a public entity, you have to comply with, it's state action. So you've got to comply with the Constitution. Whether a truly private entity could get away with it remains to be seen, because there's a whole host of other laws, like public accommodations laws and things like that. But that's not the case here. We're talking about UNC, a public university, and you're talking about Harvard, which receives probably tens of millions, maybe even hundreds of millions of dollars a year in federal grants and contract money. So the day that Harvard and UNC could say, hey, that's none of your business, court system, federal court system, that never really existed, and it certainly doesn't exist now. So yeah, it's everybody's business.
talking to William Jacobson, Cornell law professor, the mind behind legalinsurrection.com. So you just answered the question of why this is that the federal government has a place here, because there is federal money. And whenever we're talking about the private sphere, like we saw the case with the web designer who didn't want to design, was it specifically a website for somebody who was gay or involving same-sex marriages, and the court said you don't have to design it. You have the right to say no. I'm not saying you should say no. I'm saying you have the right to say no. And I think this is going to lead into a conversation regarding the public accommodation and whether or not that is still something that is a worthy standard in the U.S., or whether you as a business owner, as a private business owner, can make decisions. But in this case, as you're well spelling out, this isn't about private. This is about whether or not government money can be used in these ways. And specifically, when we talk about that Harvard case, we know that Asian students were told, step to the side. We have enough people who look like you. I mean, that's really what was said to them by the Harvard staff and Harvard admissions. And that's what was part of the complaint here, that you're telling me I'm not allowed in, not based on what you claim are the standards, but rather a standard on a color of skin or an ethnicity.
Well, Harvard denied deliberately discriminating, and they said that they only used race in their evaluations as a plus factor. And that was really what was before the Supreme Court, is can schools even use race at all? Can you have what's called race conscious decision making? I think that if Harvard had come right out and been thoroughly transparent about it and say, we are going to limit the number of Asians, I don't think they would have gotten away with that for as long as they did. But instead, Harvard has been this, trailblazing university, the top of the heap, so to speak, was a trailblazer in nuanced discrimination. They invented what's called the holistic model in the 1920s to keep Jews out, to limit the number of Jews. And they pioneered that. And they now use that same holistic model to limit the number of Asians. And they do it in very surreptitious ways, which were proven in the case. Took 7 years of litigation, took a trial, took discovery. They fought this tooth and nail. And it did come out that they had a ruse going on. And the ruse going on was a personality score. And it just so happened that the personality score was the vehicle, that soft sort of evaluation, the vehicle to keep Asians out, as if Asians as a group have, bad personalities. So, and I think that was very damaging. And even in the opinion itself by the court, they included charts that the plaintiffs had prepared showing how much different Asians were treated than all other groups, but particularly than Black applicants. And they showed Asians, and I might be wrong on the number here, but had to get like 140 or 150 points higher on the SATs to have an equivalent admissions rate as Black applicants. And there's no other explanation for that other than discrimination.
This holistic thing is I don't think people understand how pervasive it is. And of course, with your work at Legal Insurrection and the work you do regarding critical race theory and seeing what's being taught on college campuses, Butler University, right down the road from me here in Indianapolis, immediately put out a statement that they're going to continue to do a holistic review of all applicants, which really reads that Butler University, in my view, and many, many other universities, I don't want to single them out specifically, although they're the ones where I saw the tweet because it is local, have said, we see what you're saying, Supreme Court. We see that you've done away with affirmative action. We see that you've done away with race-conscious admissions, which is how UNC and Harvard were trying to deal with this. But we're going to do it anyway. That's very much what it seems that they're saying. What's your take?
Oh, absolutely. Anybody who thinks that you see a lot of headlines, Supreme Court ends affirmative action is dead, etc., is kidding themselves. These universities are completely addicted to racial preferences. It is part of their core philosophy on life. It is part of their core being. It's why we have diversity, equity, and inclusion has become a religion on campuses. They are not going to give this up. Harvard, immediately after the decision, sent out a statement that indicates how they're going to do it. So the court drew a distinction. You cannot consider the race of an individual in admissions, but you can consider that person's personal experiences with racism. And that was something that all the parties had said. You cannot stereotype students. You cannot say all Black students get treated the same, all white students get treated the same. But you can, if somebody personally has overcome racism in their lives, you can consider that. And that is the loophole through which Harvard and other universities are going to try to drive a truck. Harvard was very smug about it. They quoted that sentence from the Supreme Court, and then they say, of course, we will comply with the court's ruling, meaning that's how they're going to do it. Of course, they didn't quote the next sentence in the opinion, which says these essays and these personal experiences can't be used as a device to evade our ruling. But that's exactly what they're going to do. Anybody who thinks racial preferences are over is kidding themselves. The schools will do a workaround almost universally.
And it seems so incredibly obvious that that's the case. And as you point out, the smugness there of Harvard, as I pointed out, the point from Butler, they are seemingly just very okay with this. And as a matter of fact, not only okay with this, it seems to me that they're making the argument that you should accept this, that they know how to create justice. Does affirmative action, do you believe it did then? And we know I mentioned former Justice Sandra Day O'Connor. Do you believe it then engaged some level of justice, and was, and as a matter of law, was it about righting a wrong? And are these schools, in taking a look at race as their key factor for admissions, it would seem, are they righting a wrong?
Well, the wrong that took place many decades ago, and to some extent centuries ago. But since the mid-1960s, we've had very strong laws. We've had unstated affirmative action since the 1970s. And I use that term specifically because the dean of Berkeley Law School, very highly ranked, top 10 law school, was caught on videotape using that term, unstated affirmative action. Now, he was talking about the hiring process at Berkeley Law School, that we can think it, we can vote for it, but we can't say it. And that we can't say we're doing affirmative action because that's actually banned in California. By proposition, it's banned. So what you have multiple generations now where there has either been explicit affirmative action under the Grutter ruling and the prior rulings to that, or you've had unstated affirmative action. So to argue in 2023 that we have immediate past wrong that needs to be narrowly remedied, maybe that flew in 1970. And I think you can make a good argument in 1970 for that, but not in 2023. It's not about righting a wrong to particular individuals. It's a social agenda.
Now, there has been a tremendous amount of response to the affirmative action ruling, to this ruling about free speech, where you can't force a web designer to make a website they don't want to make, just like you should never have tried to force a Masterpiece Cake Shop to decorate a cake for a same-sex couple. And I will tell you, and I would debate it with you another time, that I'm somebody who opposes the public accommodation. It seems that while I believe it in cultural theory, that in the legal world, I don't think any business should be forced to serve me. If you are a restaurant, fully privately funded, and you don't want to serve me, well then, my gosh, don't serve me. I think that should be allowed as a case of and a concept of freedom more than anything else. But that's a subject for another day. I want to share with you this. This was the headline of an article from Mehdi Hassan over at MSNBC, who died and made the Supreme Court a Congress. And it's all about how here we have a Supreme Court. Now, of course, the Supreme Court, it's radical because it has some conservatives on the bench. Now it's a radical Supreme Court, and they're legislating from the bench. And we shouldn't listen to these responses anyway. We shouldn't listen to these decisions. As a matter of fact, we should pack the court. We should have more justices on the court because nothing in the Constitution discusses the number of justices. And we shouldn't allow them to have this level of control, mainly because they're saying things we don't like on the political left. How do you respond to that? How do you teach your students to respond?
Well, I think that what you're seeing go on is a frustration from the left that the one major institution they don't control is the Supreme Court. And to call the Supreme Court activist is really having it backwards. They're not forcing anybody to do anything. They're saying, they're protecting individual liberties in the case of the website designer. It's not so much that she can't serve people, but she can't be forced to express a message with which she disagrees. And the same is true in the affirmative action cases. They're not forcing anybody to do anything. They're saying they're pointing out the limits on government's ability to do things, that individuals have a right to equal protection of the laws, and the government can't, disrupt that, can't impinge on that. And so most of the Supreme Court decisions are the exact opposite of a totalitarian or authoritarian mentality. They're enabling individual freedom. And so that's really, bizarre to hear those sort of complaints. But Mehdi Hasan and people like that, it's just purely political. They want power. They're so used to having power. And they never complain when the Supreme Court would make things that change the nature of our society, whether you like them or not, like finding a right to abortion in the early 1970s, or finding a constitutional right to same-sex marriage. These are things that changed the landscape of the country in many ways. And you didn't hear people like Mehdi Hasan and others at MSNBC complaining about it when they did that. And so these Supreme Court decisions are actually just empowering individual rights and scaling back government control.
William Jacobson, Cornell law professor, the mind behind legalinsurrection.com. I appreciate you, as always, being a part of what we do here. Can't thank you enough. And you need to subscribe on Rumble, be a part of what it is we do and how it is we do it. Go subscribe. If you're watching us on YouTube, subscribe on Rumble as well. We'll keep bringing you the good stuff, keep having the conversations. Keep talking about the things, I don't know. I don't think people dig in enough. I don't think they dig deep enough. I don't think they're pushing it. It's all just top line. Yeah, these people are bad. It's important to know what the hell is up, for the love of God. That's just one man's theory. And my thanks to Americans for Prosperity, americansforprosperity.org, economic liberty, free speech, our sponsors. Appreciate them letting us do what it is we do. And I will catch you next time, everyone.